Hi, welcome back to another episode of What to Expect When You're Arrested. Today, we're going to be talking about dismissals, but before we get to that, we do have a free download for you. It's 4 things you should be doing right now if you've been arrested. You can click down in the show notes and there's a link there, and we will send that right out to you. Also, in addition to hosting this podcast, I am a criminal defense attorney here in San Antonio. So if you're being charged with a crime here in the San Antonio area, feel free to give us a call at 210-775-0852, or we do have a link down in the show notes where you can schedule your own free consultation. There are 3 ways that your case can normally end. The first is that it can be dismissed. The second is it could end up in trial. Or the third is if you end up accepting a plea deal from the district attorney's office and it works out that way. When your case is dismissed, it means that your case is over and there's nothing more for you to do on your case. In almost all circumstances, it's the prosecutor who is the one who's dismissing your case. And they can dismiss it for a number of reasons. There are a few exceptions where the court can be the one that dismisses your case. So if your right to a speedy trial has been violated, then the court would order that your case be dismissed. In most circumstances, though, it's the prosecutor who is the one dismissing the case. Now, it's your choice if you're being charged with a crime, whether to take a plea agreement or to take your case to trial. And it's up to the prosecutor, essentially, whether to dismiss the case or take the case to trial. So if the state feels like they don't have a very good case or they can't prove your case at trial, then their choice is to dismiss that case instead of taking it to trial. Your choice, if you don't have a very good case or the state has a strong case against you, or for whatever reason, you don't want to take your case to trial, then your choice is essentially to take the offer from the district attorney's office. Now, there are several reasons why a prosecutor may choose to dismiss your case. One of those is that they can't prove the case at trial. At trial, they would have to prove beyond a reasonable doubt that you did whatever you're being accused of doing. If they can't do that for whatever reason, if they just don't have enough evidence, or for whatever other reason, they don't think they're going to be able to prove to a jury that you committed this crime, then they can make a decision to dismiss the case at that point. Another common reason, and kind of related to the last one, is if there's a necessary witness who is missing. At trial, the prosecutor would call witnesses to testify against you, and they would use that testimony to try and prove that you did whatever you were accused of doing. And those could be officers who are the witnesses, or it could be the victim, or it could be just bystanders. There are a number of different witnesses that they could try to use to try and prove that. However, there are reasons why a witness may not be available. It could be an officer who's no longer with the department. Maybe a witness has moved out of state and the state isn't able to get them to come in and testify. Or maybe somebody doesn't want to come in and testify. So there are a number of reasons why they may not have a witness who's available. And if that witness is going to be necessary for them to prove what happened, then that may end up with the prosecutor choosing to dismiss the case. Another reason is if the cop just messed up too much. If there was an illegal search, or if there was an illegal arrest, or some other mistake made by the cop, then that could be a reason for the state to dismiss the case as well. And lastly, when there's a plea agreement, sometimes they will choose to reduce the charge from a felony to a misdemeanor, or they may choose to dismiss certain cases in exchange for you pleading to other cases. Now, what does it mean for you when a case is dismissed? Like I mentioned earlier, almost all of the time, people want a case dismissed when they come in and talk to me. But what does it actually mean when a case does get dismissed, and what doesn't it mean? So first off, it means you're not going to have any more court dates because that case has been dropped. It also means you don't have to continue checking in with your bondsman because you're not on bond anymore. So any bond conditions that there were, like ignition interlock or no contact orders or whatever else may have been a condition of bond, all of those are gone. Also, if you were having to report to pretrial services, then you don't have to report to them anymore. I normally recommend to people after their case gets dismissed that they contact their bail bondsman and pretrial services just to give them a heads up that the case was dismissed. That way, they're not continuing to get these phone calls from those places, and just kind of as a courtesy, as it just makes things a little bit easier. What it does not do is it does not clean up your record. To get the full benefit of a dismissal, you have to go forward with getting an expunction. And in most cases, you'd be eligible for an expunction, although there are certain circumstances where you wouldn't. But if anybody does a background check on you, it's still going to show that you were arrested and charged with this crime. It should just also show that ultimately the case was dismissed without any sort of plea agreement or anything else, which is a good thing. But you still generally have to check off that box saying that you had been arrested, even if your case was dismissed, unless you get that expunction. And that's why I always recommend to people who've had their case dismissed that they look into getting an expunction and talk with their attorney about that so that they can get the full benefit of that dismissal. A dismissal also doesn't mean that this case is never going to be brought back. If the statute of limitations still allows for it, then the state can refile your case, even if your case has been previously dismissed by them. There may be new evidence. There may be some other reason why the state chooses to refile the case. In most cases, they don't. I can't think of anything any time off the top of my head where a case has been dismissed and then brought back, but it is possible. There are a couple of things that you can do to make it more likely that your case gets dismissed. The first of those is to make sure you're represented by an attorney who's really working to try and get a dismissal on your case. If you've got an attorney who's just trying to get the case closed out and is pushing you to take a plea agreement on the case, then it's not as likely that your case is going to get dismissed. Ultimately, if the case is bad enough or for whatever other reason, your case may still get dismissed. But if you want to maximize the chance that your case does get dismissed, look for an attorney who you trust to fight for you and to fight for that dismissal. The second is knowing your case and making the decision to go for a dismissal instead of accepting an offer from the district attorney's office. I recommend sitting down with your attorney on your case and going over the evidence and the strengths and weaknesses of your case, because ultimately, if this case goes to trial, you should know what that's going to look like before you make the decision about taking any sort of plea agreement from the district attorney's office. If there are weaknesses in your case that make it look like your case has a chance to ultimately get dismissed, and if you don't accept a plea agreement, then there's a chance your case is going to get dismissed. Sometimes you have to be willing to push your case to trial in order for it to get dismissed. There are a lot of cases where the prosecutor is not going to dismiss the case until they have to make that decision about whether this is a case that they're going to take to trial or whether it's a case that they're going to dismiss before taking it to trial. Because of that, you have to be also willing to push your case towards trial to try and get that dismissal, even if they are trying to avoid dismissing your case. I hope all of this has been helpful. If you have any questions about dismissals, or if you're being charged with a crime here in San Antonio, feel free to give me a call. My phone number is 210-775-0852. And again, we do have a link down in the show notes also where you can get that free download or schedule a free consultation with us. And I hope that you have a great day.